Podiatrist. My name is Chad Apple, and I'm the Associate Director for the Center for Professional Advocacy at APMA. Tonight's webinar is the fourth installment of the APMA Reimbursement webinar series. As a reminder, the presentation is being recorded and can be viewed again at www.apma.org/webinars. Tonight's webinar will last approximately 1 hour, and we should have time at the end for a few questions. You may write your questions in the question box located on the webinar toolbar. It is now my pleasure to introduce tonight's presenter, Donna Senft. Donna is a principal in Ober Kaler's Health Law Group, where she focuses on healthcare transactions and regulatory matters. Donna's practice includes advising healthcare providers and practitioners regarding acquisitions, mergers, and internal reorganizations, focusing on obtaining licenses, certifications, and billing privileges. In that regard, Donna has expertise in Medicare and Medicaid enrollment matters, including completion of NPI applications and CMS A55 forms. Donna, take it away.
Thank you. I appreciate the opportunity. So tonight, I'll just quickly, a couple of things we're going to focus on. One of the things that I think is a very important compliance task now are your enrollment filings complete, current, and accurate. Is it time to revalidate, and what do you want to do to ensure that process goes smoothly? What are the mechanisms that government agencies are using to verify that you're maintaining compliance, particularly with Medicare enrollment, with the Medicare enrollment rules, not so much claim submission, but the actual enrollment requirements? How grave are the consequences if you don't comply? And then I've selected several of the cases. There are quite a number of Medicare enrollment cases that come out each day, and I selected a few to talk about so that you can see some of the reality of what's happening in these cases. So just going through and looking at common mistakes or incompleteness of Medicare enrollment data, just hitting first of all the NPI data, which is an important database because that is your billing number. And some of the things that I'll see when I go to do an 855 application for a client and I pull up their NPI database, I'll see that, the NPI data isn't exactly accurate. Oftentimes there's problems with the legal entity name not being fully spelled out, or the DBA trade name not being accurate. I oftentimes see that there's also not timely updates to data, so that the authorized official listed may not match who's the authorized official for the 855. Addresses sometimes don't get updated. Licensing and payer identification numbers don't always get placed into the NPI database after they're obtained. And then just generally speaking, there are problems with NPI numbers are not necessarily deactivated when they're no longer needed, such as following a transaction, and folks are not necessarily good about protecting their NPI data. So you really need to be careful with it. I suggest changing your username and password periodically, keeping your username and password in a safe place. And if you end up not needing to use the NPI, such as following an acquisition, be sure to circle back and deactivate it after all claims have been adjudicated. So just quickly going through some terminology so we're all on the same page. Pecos is the database for Medicare. We hear people talk about it. Do you have an enrollment record in Pecos or Internet Pecos? And just so we understand what Pecos is, the Balanced Budget Act of 1997 required Medicare to come up with a different way of tracking Medicare enrollments. Individuals were enrolling in Medicare through their Social Security number, and same thing with beneficiaries. And so there were a lot of Social Security numbers that were on a lot of documents like remittance advices. And so Medicare was tasked with coming up with a different identifier, and that's what, and also to keep all the data in a very safe place. So Pecos is the electronic system that was developed to maintain all of that data in a secure fashion. And enrollment data began being entered into Pecos in 2002 through the fiscal intermediaries for providers and through the carriers in 2003. Since podiatrists often have DMEPOS enrollments as well, DMEPOS data was in a separate database until September of 2010. So if you enrolled in Medicare before, let's say 2003, the likelihood of your data being complete and accurate was probably not that great, because what happened is folks would submit information via oftentimes just by sending in letters. So what happened in 2003 and having this Pecos database was the development of what we now call the A55 forms, which are the enrollment forms, and then followed after the paper forms, which have gone through several renditions. Is there's now the ability to enroll using Internet Pecos. And I know that the government has really been pushing very strongly to try to get folks to use Internet Pecos. But I will tell you, I want to talk just for a little bit about some of my concerns about Internet Pecos and just some cautions. One of the issues that I've had with it right out of the box is if you do an application through Internet Pecos, when you print the data that you just entered into Pecos, into Internet Pecos, you get a redacted copy. The copy that prints out redacts the Social Security numbers and the dates of birth. And I've had discussions with CMS. I find that very troubling from the standpoint that it is your proof that you entered complete and correct and accurate data. And when you sign the certification in Section 15, you're signing that the information is accurate under penalties of civil and criminal sanctions. So if you've got civil and criminal liability, you ought to at least be able to get a complete copy of what you have entered so that you could prove that you entered the information accurately. It is a more cumbersome process if you want to have someone review your forms. It's also more cumbersome if you happen to be involved in an organization that has a more complex ownership structure. But for example, I have a lot of clients who like for me to review their forms before they get submitted. If they use Internet Pecos, it's a very difficult process to do. But I also do a number of appeals of cases where there's been a revocation of billing privileges and or deactivations of billing privileges, and what I have been, and also the enrollment effective date appeals. And I have had clients tell me that they knew that the data was in Pecos, Internet Pecos. They remember entering it. They know that it was signed. They know that there was a record in there, and all of a sudden it has disappeared. So if you're using Internet Pecos, the best way to protect it is I would print a screenshot of every shot you're entering. Make sure you print and maintain a complete copy of the application when you're done. Make sure that you print whenever you get verifications that signatures, electronic signatures have been received, and periodically check back and see what the status of it is and print those web pages as well. Because the more that you can at least substantiate that you had at least submitted an application, even if it disappears, your chances of winning an appeal are much greater. CMS's attorneys have recognized that there are some problems with the Internet Pecos. Accuracy of data on the A55. So I'm going to talk about some of the common mistakes, and we'll go into some of this in a little bit more detail. But legal entity names, you have to have, complete and accurate legal entity names. It's got to match what is the IRS has in their database. This becomes problematic if you want to undergo a name change, whether it's a legal entity name or a DBA name, and you want to try to get everything to match up. Full individuals' names not necessarily matching the Social Security Administration data. Somebody gets married or divorced and they don't update the Social Security, but they update their A55 and it doesn't match. Authorized officials. CMS has been focusing more recently on authorized officials because there are individuals who don't have legal authority to bind who are signing applications saying that they are the authorized official. In order to be able to be an authorized official, you have to have the ability to legally bind the organization. So somebody that's on the governing body or somebody that has been appointed by the governing body to have that kind of authority. Delegated officials, again, CMS has started to check to be sure that the individuals who are listed as delegating are truly meet the criteria. In order to be a delegating official, you need to have an ownership or controlling interest and or be a W-2 employee of the enrolled entity. And zip codes, full 9-digit zip codes, there's a lot of focus on trying to maybe move to using the 9-digit zip code as a unique identifier for things like, say, where services were provided. Right now, CMS doesn't use it, but they've been collecting 9-digit zip codes on the A55. When you're going through an application, whether it's a new enrollment or revalidation, it's important to leave no blanks. You don't want to have an application rejected for being incomplete. You can always put not applicable or pending, but just try not to leave any blanks so that someone doesn't allege that it was an incomplete application. I'm going to talk more specifically about the next 3 areas on the next slides. Practice locations. So there's a concept, and we'll talk about this in the cases, and it's getting a lot more attention, where in order to become a Medicare enrolled provider or supplier in the first place, you have to have an operational practice location. It's a very basic premise under the Medicare rules that didn't get a lot of focus until recently, and is getting more focus with the site verification visits and for other reasons we'll talk about. But operational is you have to have a qualified practice location that's open to the public, that's properly staffed and equipped and stocked and ready to provide the services. So that's the general rule for what operational is for all providers and suppliers. Then you get to DME suppliers and IDTFs who have to have separately enrolled practice locations and even more requirements than just the being operational. The other issue with practice locations is you'll sometimes see where the signage on the location doesn't match the information in the A55 form. And in today's world where you have site verification visits, if your name on your outside signage isn't listed on your application in Section 4, you could have a site inspector show up and they're looking at Section 4, and they're looking at the name in Section 4, and they're looking at the name on the sign, and they don't even bother to come in because the names don't match. So you always want to make sure that your Section 4 information on your A55 matches the information on the outside signage. You also want to explain any unusual hours of operation. Site verification visits are to occur from 9 to 5, Monday through Friday. So if you're not open during those hours, I suggest that right on Section 4 you put if you have limited hours of operation at a particular location, or if there's some unusual aspect to the access of it. For example, if you happen to have a podiatry location where you lease space, for example, in an assisted living facility or a nursing facility, right in Section 4 I would put this location, because they're going to come up and it's in the sign, the outside signage is going to say something like Sunny Acres Nursing Facility, and the site inspector is going to be looking for a podiatry practice. So if you put on there, this podiatry practice is located inside of Sunny Acres Nursing Facility, that site inspector, if they're given, because my understanding is, again, we don't get to see their work papers, but my understanding is the site inspectors are simply given Section 4 and told to go find this location. So the more information that you have in Section 4 to identify your location, the better it is that the chances are that you would have a successful site visit. Section 5, organization with ownership and controlling interests. A lot of times in smaller practices, for example, folks might think, well, that doesn't apply. The only people who have ownership interests are individuals. We don't have any organizations. Well, the way that CMS defines organizations with ownership and control is control is defined as any day-to-day operational control, which can be a management company. It could even possibly be a billing agent. When CMS is looking at control, they're looking at 2 things. They're looking at quality of care and patient services, and they're looking at claim submission. So if you have a billing agent that assists in helping identify coding issues and claim submission issues, they may be an organization with a controlling interest. Ownership, I've spelled out. Ownership is pretty easy with respect to actual owners, whether it's a LLC or a corporation. The ownership interests are typically easy to identify up the chain as to who holds a 5% or more interest. Just a couple of unique things, though. If the enrolled entity happens to be a partnership, limited partnership or a general partnership or partnership, then all of the partners need to be listed irrespective of what their ownership interest is. So I've seen partnerships where there's a 1% general owner and a 99% limited partner. The general partner that with a 1% interest still would have to be listed. The other piece of the federal statute for reporting ownership interest that is oftentimes overlooked is there's a requirement to list an entity with a financial ownership or control. So financial ownership, and we're going to talk about that in a minute, because that's another concept that is very common among enrolled providers or suppliers but gets overlooked. So in Section 6, with individuals with controlling interests, you have the same type of requirements for listing individuals with controlling interests and ownership as you do for organizations, with the exception that an individual with a controlling interest is now not only somebody who has the ability to influence day-to-day decisions, so a governing body members would all be listed, officers, but also any individual who, again, has given authority to bind the entity. So, for example, a lot of businesses that are, a lot of healthcare companies are now buying assets in limited liability companies. It's a very common form to use to hold your assets because it doesn't have the same formalities that a corporation needs to be. Well, limited liability companies may or may not be owned directly by another individual. There might be an intervening holding company. And because they don't have to have officers or directors, there may not be anybody that's been designated as having authority to bind that entity. And that's something that Medicare says needs to occur. No matter what type of corporate form you have, there has to be at least one or more individuals who have been given authority to enter into agreements and to bind the entity to adhere to the rules. And any of those individuals have to be listed on the A55. Managing employees is another area that's getting increased attention because CMS says in addition to those folks who have control, we want anyone who is responsible for overseeing day-to-day operations in a managerial position to be listed. And that gets to be a trickier question, who is a manager? Is it, is it everyone that holds a title of some type of administrative position? And again, I just go back to the main things that CMS is concerned about is quality of care, patient care, and billing and claim submission. So if you have an individual who is responsible for the billing and for getting the remittance advices and for making sure that the co-payments were obtained and making sure that the claims processed and were paid appropriately, that individual likely would be considered a managing employee in Medicare's eyes. And that may be someone that's, again, at a billing agency level and not necessarily a W-2 employee. Ownership interests, again, are fairly easy to track. I won't spend a lot of time on that, but just remember the nuance of partners have to be listed irrespective of their partnership interest if the enrolled entity is a partnership. So I talked about financial ownership or control, and I want to come back to this. This really is a concept where Medicare wants to know, and this is a federal statute, so it's a legal requirement to have to report it, but Medicare wants to know, is there any financial institution or individual that holds a secured interest in the assets of the provider? So secured interests are a legal concept where someone actually takes out a security interest in the assets such that they stand in front of other creditors. So it's really a way of kind of marking your place in front of other creditors. And of course Medicare cares about that because if your company starts to go belly up, Medicare wants to know, are we first in line to get our money? Is there a secured creditor in front of us? Are there two secured creditors in front of us? Well, a lot of times businesses will take out, for example, a revolving line of credit, and they will secure the revolving line of credit with the receivables. and the receivables will be worth more than 5% of the total assets. That would be a secured interest that would have to be reported to Medicare, even if you didn't have any outstanding balance on that revolving charge credit line. So even if you had a revolving credit line where you had no debt at that point in time, but if it was secured with more than 5% of your assets, that is a financial owner under the Medicare law that is required to be disclosed on the A55 form. So the way you see this come up is you'll see it if somebody is buying a business and they secure, in order to get the money to invest and to buy the business, they take out a loan, and the loan is secured with the receivables, or the loan is secured with other assets that are used in the running of the business. So again, it's just a kind of obscure area of the Medicare rules that's not very well known. Billing agents. I just want to spend a little bit of time talking about billing agency and billing agency roles. As I've spent more time on the EDI claim submission side of the enrollment, it's become very clear to me that generally speaking, I've seen a lack of understanding of what is supposed to be reported on the A55 when it comes to billing agencies. So again, just to understand the terminology, CMS defines a billing agency as any company or individual that you contract with to help prepare, edit, and or submit your claims. So if you're using a clearinghouse to submit or transmit your claims, that is a billing agency under Medicare rules. If you're using you have a billing service that helps you actually prepare the claims that get sent to the clearinghouse, that is also a billing agent. And let's take another scenario. You have a larger organization where you have a management company that is providing consulting services, or a corporate, you hold employees in another organization and lease the employees to the provider entity, so that the folks who actually do the billing are actually in another LLC or corporation. That would be a billing agent because it is an employee of the enrolled entity itself. So the reason that you're supposed to put billing agencies on your A55 is when you submit the EDI paperwork to be able to submit claims electronically after the enrollment, there's a checkbox on the EDI paperwork that says, I've already reported this information to Medicare on my A55. And you're supposed to check that box that you've done that and sign the certification that the information matches. Well, the reason you have to do that is because the information in enrollment, as I said before, goes into Pecos. The folks who work in enrollment and enter data into Pecos have no ability at the contractor level to see the claim system. And vice versa, the folks who work in the claims department have no ability to see what's in Pecos. And that's purposeful to keep a complete division between the two sides of Medicare, complete division between the two branches, so that nobody can enroll a dummy provider, submit claims, go into the claim system, and process the claim. So it's a purposeful security measure that CMS has in place. But because of that, the only person in control of the information then is the provider or supplier, who has to put this information both on the A55 as well as on the EDI. A couple of things just about CMS A55 INR forms, since that's another part of your practice. One of the things that's important with the A55I form is the correspondence address. I've seen a lot of practices, whether it's podiatry practices, PT, physicians, I've seen a lot of practices where whoever completes the A55I form says, well, I want to make sure we get the revalidation, so they put the practice address information as a correspondence. The A55 is a personal, individual enrollment application. It should have the individual's personal information in there, their home address, their personal email. Because if that individual leaves your practice and 5 years later it's time to revalidate, and the revalidation comes to the correspondence address, you now have to go figure out how to find that individual to let them know that they have a request to revalidate. So that's probably the biggest thing I've seen on the A55I form. The A55R form It's a very simple form, as you all know, to complete, so I don't need to spend any time on that, but just wanted to highlight that if you happen to have a reassignment from an independent contractor, not a W-2 employee, CMS, when the rules were changed to allow reassignment from an independent contractor, program integrity said that's fine, but if it's not a W-2 employee, then we expect another written agreement that has two terms in it. One is that the independent contractor will be jointly and severally liable for the claims for any overpayments. That means that not only the supplier but also the independent contractor are liable for the claim overpayment, should there be one. But also, because of that liability, that independent contractor has to have an unrestricted access to the claims that were submitted for the services that he or she provided. And that's an aspect of the contracting piece that oftentimes gets overlooked in the rules, that there's this extra requirement for a writing if the reassignment's from an independent contractor. Just a couple of tips on Section 17. One of the things that it says on there is if you have a lending relationship with a bank in which you're getting your electronic deposits, you need to have the bank waive its right of offset. So again, if you happen to have, for example, a credit card account through the bank where you have your electronic funds deposited, you would have to have in that agreement to have the credit card. There's usually, when you have more than one account with a bank, there's usually a clause that says if you're overdrawn in one account, we can pull from another account to pay it. Medicare says you can't have that kind of an agreement with a bank. If you're putting Medicare receivables into account, they can't have a right to draw against that account if you've got an overdraft in another area, so they have to waive their right. With respect to the 588 EFT agreement, just a couple of changes in the rules. You can no longer you used to be able to designate and allow a bank account to go to a parent. It's now only if you're enrolled chain home office, which doesn't apply to suppliers. So the account has to be in only the name of the enrolled entity. If your account doesn't match, the exact name, you want to have it, I don't know, ABC government accounts as opposed to your complete legal name, then you'd need a letter from the bank just confirming that that account is in the name of and for the benefit of this particular provider. So I just quickly want to flip through some of the rules with respect to enrollment updates, and these you can go through at your leisure, but for the most part, you really do need to pay attention to updates. Ownership and control, every provider and supplier only has 30 days to report a change. Final adverse actions, physician groups, DMEPO suppliers, so podiatrists and DMEPO suppliers only have 30 days to report an adverse action. I wanted to spend a little bit of time in the slides walking through what an adverse action is. Most of these are pretty self-explanatory, but the one that probably sticks out a little bit as somewhat misunderstood is the suspension or revocation of a license. If you agree to, let's say, some of the times the licensing boards want to do sanctions where they will suspend and then stay the suspension, so the licensee never really loses their license. It's an infringement that's not harsh enough to want to take the license away, but the licensing board wants to send a signal out, and so somebody thinks, well, I never really lost my license. Medicare doesn't see it as that. A suspension is a suspension, even if it gets stayed. So you can go through the list of what are final adverse actions that need to be reported. You'll see on here there's nothing about having to report if you have a financial penalty, like a civil monetary penalty as a result of some type of a RAC or a ZPIC audit, or a settlement, for example, with the OIG in which there's a financial settlement. So financial settlements are not reported. It's more licensing actions, legal consequences, and other types of revocations of billing privileges. But I also listed out the various different types of crimes that are required to be reported, and most of these final adverse actions will almost ensure a Medicare revocation will follow. So you just need to be aware of the fact that there are grave consequences if you end up having to report any of these actions, and it's the type of thing where depending upon what it is, you may want to try to figure out a way to report it, but see if you can get in front of it to see if you can avoid a revocation. Additional practice, the addition of a practice location, generally most suppliers have 90 days to report it. Physicians only have 30 days. So physicians and physician groups only have 30 days to report if they're going to add a practice location. Practice location additions don't work for certain types of providers and suppliers like the MIPOs and IDTFs because they have to separately enroll each location. And again, we won't go through the DME rules. There's, podiatrists have some exceptions to some of the general rules that other DMEPO suppliers are required to adhere to. And relocation of an existing location, again, typically 90 days to do. But I will say that if, in fact, you have to have, it's not a very common problem for podiatry practices, but a lot of practices have to have licenses for where they locate, where they're, in order to operate at a particular location. So if you're in a jurisdiction where you actually have to have a business license, and that business license, there's a licensing website where they post it, and they post the address associated with it, you may want to try to do a more timely than a 90-day reporting of a relocation, because we'll get to what are some of the verification checks, but one of them is a licensing verification check. So you wouldn't want Medicare doing a licensing verification and see that you've moved and you haven't reported the move, because if they find that discrepancy, they're likely to turn off the number at least during the time period they investigate it. And then just generally speaking, most other enrollment changes need to be reported in 90 days. So things like you're changing your telephone number or your fax number or your special payments address, those types of changes would have a 90-day reporting requirement. So I want to spend just a little bit of time for revalidation. Revalidation is required since the changes in the enrollment regs that occurred even prior to the Affordable Care Act. Back in 2006, there were changes in the enrollment regs requiring revalidation, and it's every 5 years except for DMEPO suppliers, which are every 3 years. So you have 60 days from the time you get a request to revalidate, but you may revalidate at any time, and I raised that as an issue. If you happen to be doing, for example, a stock transaction where you are buying the stock or the membership interest of another provider, another podiatry practice, and you want to ensure that there is complete and current and accurate information on file, you could do a revalidation, a voluntary revalidation post acquisition, just to be sure that you've got a complete A55 on file. That's perfectly fine to do. As I said before, the contractor sends a request to the correspondence address. That's why in the A55I you want to have home correspondence addresses, but it's another reason why you want to keep your addresses up to date. You don't want to not have a revalidation letter show up and end up with a billing privilege revocation because you failed to respond to revalidation. There's also a web page that CMS maintains where they have a list of providers and suppliers that have been sent letters. So if you think you're in that window and you haven't gotten a request to revalidate, you might want to be checking CMS's website. So I just put a link to, I put the web address there, and when you go in there, you'll see there's also educational materials in the revalidation process. There's sample revalidation letters so you can see what one looks like. But just remember that revalidation does not negate the need to report changes. So what are the mechanisms that CMS has to try to verify compliance with the enrollment rules? The Affordable Care Act required CMS to establish risk categories, and there are now 3 levels of risk categories in the Medicare program: limited, moderate, and high risk, and it's the risk of fraud. And the screening procedures increase based upon the risk. So I put a couple of slides in here, and you can look at these at your leisure. I also put the Medicare, where in the Program Integrity Manual you will find a list as to who is a limited versus moderate versus high and what type of screening is required for each one. So I put the tables that were in the original regulations when they were published, but you will see as you go through this that not every type of provider, supplier, entity is listed, and so the Medicare manual was updated to take some of those oversights into effect. But as you can see, physician groups, podiatry groups are limited. However, you get into DMEPO suppliers. DMEPO suppliers are moderate if they're already enrolled and high risk if they're not enrolled. So even if you happen to be a podiatrist that's in a limited risk, if you have a DMEPOS business, the DMEPOS itself will be in a high-risk category as a new provider, moderate-risk category. So what does that mean? Do you always just stay in the list of your category? No. Any particular provider or supplier can be made a high risk, and there's conditions under which CMS can do that. So, for example, if there's been a final adverse action that's reported, CMS could raise the risk category. There's also reasons to do it if it's been following an enrollment moratorium that we'll talk about later. Every provider or supplier, limited, moderate, high, goes through some specific checks, and most of these are done on initial enrollment on a monthly basis and at the time of revalidation. So I talked before about licensing checks. One of the things that the Medicare contractor has to do is every month is any license that's required has to be verified to see it's still in effect. So they're going to go to the podiatry board's website, and they're going to make sure that every podiatrist license is still in effect. They have to do checks against the Social Security Administration, so checking Social Security numbers, but they also get a file with the deceased individuals. Now, I personally have a problem with CMS's policy. They have a policy now that if an individual who's an owner or a provider shows up in the deceased file, they are supposed to deactivate billing privileges in 30 days. Well, I've had situations where the where the physician practice, it happened to be physician practice, was solely owned by one individual who died suddenly. And you cannot change, you can't unwind an estate and sell a practice in 30 days. The good news is that even though it's CMS's policy, the Medicare contractors understand that, and so you can usually work with them, but just recognize that that occurs. They have to check the IRS documents that are provided to make sure that the tax identification number matches the IRS name that's on the paperwork. They have to verify that the NPI data is accurate and that it is consistent with what's on the Medicare enrollment form. The one that's most troubling of this list, however, is the National Practitioner Data Bank. And at this point in time, even though there's a requirement for CMS to verify the data in the National Practitioner Data Bank, there isn't a procedure in place yet for them to do that. So, for example, they can check if you're, I happen to be in Maryland, so if I was a podiatrist licensed in Maryland, CMS would go to Maryland's licensing website and check to see if my license was in good standing. But let's say I had had a licensure sanction when I worked and lived in Pennsylvania, but I didn't report it to Medicare, but it's in the National Practitioner Data Bank. When CMS gets access to the National Practitioner Data Bank, I can assure you there are going to be a lot of revocations for a lot of individuals who failed to report licensing actions in other states because they didn't, either because they didn't think it was pertinent, because they were no longer in that state, or whatever the reason is. But that is going to be a very scary time when CMS actually gets access to that database. So those are the things that everybody would go through: limited, moderate, or high. Now you get into the other types of screenings that are only applicable to moderate and high risk. Any moderate or high risk provider has to have a site verification visit. And what's interesting is the purpose of it really was initially announced as the purpose was to determine that the enrollee was operational. But over time, those site visits have also been used to see if the provider or supplier is actually in compliance with the rules applicable to their type of program. So it may not be as simple as just come by the location, make sure it's open, make sure, beneficiaries could access it, walk in and be sure, that you can get into the door, but may actually be followed by some questions about how are you complying with your rules. And so it is important to just, be a little bit in a prepared mode to be able to pass a site visit if somebody were to come in. So again, what the contractors are being asked to determine specifically is a facility open? Are there personnel there? Are customers able to access the facility? Does it appear to be operational? And I wanted to put in the actual definition from the Program Integrity Manual so that you could see, again, this is coming up recently where I've had a couple of folks call me who wanted to enroll in Medicare and submitted the A55. They weren't actually operational yet because they wanted to wait until they got their enrollment through, and Medicare came out and did a site visit and saw they weren't operational, they weren't open, they weren't seeing anybody, there wasn't anybody on the premise, and the enrollment was denied because they didn't meet the definition of operational. In addition to just the core for operational definition for all providers and suppliers, the MEPO suppliers have some additional requirements with respect to operations, some of which are applicable to DME businesses that are operated by physician practices and some of which aren't. But it is important that even though these requirements, particularly like the requirement for signage, the requirement to be open 30 hours a week, are only specific to DMEPOs because of the site verification visits and the fact that even though they have to be done for moderate risk, they could be done for anybody at any time. I tell all my clients that, the best practice is put a sign outside that identifies who you are and what your hours of operation are. Because unless you have a sign posted, you run the risk of not being able to pass a site verification visit. So again, what's the guidance given to site inspectors? Just that they have to, they're supposed to make visits between 9 and 5. If no hours are posted, if there's hours posted, they're to make a visit during the posted hours. So if you're only operational at, let's say, a location, you have a small location where you're open from 9 to 1, if you have no hours posted there and they come in at 2 or 3, you could end up with a failed visit, even though as a non-DMEPO supplier, you didn't have an obligation to post those hours. So one attempt only if it doesn't appear that the business exists there at all. If it appears the business exists, but nobody's there, then a second attempt is required. The site inspectors are supposed to document the visit, take photographs, complete a report, sign a declaration to the facts of the visit. What is concerning is that even though they do that in a revocation, in a failed visit, you don't always get that documentation to be able to file as vigorous of an appeal as you'd want to. So what are some of the ways if you do happen to, or what are the repercussions if you do fail a site visit? If it's a site visit for a new enrollee, the application will be denied. If it is an existing provider or supplier, within 7 days of the second or first, if it didn't appear to be open, site visit, you get a revocation of billing privileges. So what are the things you can do to try to avoid a failed site visit? Well, keep your practice location information on file current so that they don't go to the wrong address. Timely report any changes in your business name or in your hours of operation. Again, if you've reported, if you haven't reported that you have limited hours, you're going to drop down between less than 9 to 5. I suggest submitting a Section 4 that reflects the hours you'll be operational. Make sure that your outside signage is accurate. Post your hours of operation so they don't make a visit when you're not there. And, again, keep your enrollment data up to date with respect to your location. As I said, it's a little bit disconcerting that there are some procedural safeguards that are lacking, like not being able to get a copy of the site inspector report before you have to file an appeal. But the other concerns that I have is, and this is not uncommon, I just read a case actually a couple of days ago where the person was on the premises, the site inspector took a picture, and their car was in the parking lot. They were on the premises, but they didn't get to the door in time. The inspector walked away. I've said to CMS, why couldn't you have a kind of a backstop that if the inspector's there and knocking on the door and they can't get in, that they have to call and make sure that nobody's inside and just hasn't hurt them. So there are some real concerns with how the process works, but again, it's just I raise these issues so that if you're ever in a situation where you failed a site visit, just recognize that there are some really important quick steps you want to try to do to try to have the best appeal possible. Criminal background checks is the final screening that is only applicable to high-risk enrollees, and it hasn't gone into effect yet. The criminal background check screening would be required for any individuals with a 5% or more ownership, direct or indirect, but until the procedures for how to do the fingerprinting, protect the fingerprint reports, make sure that there's appropriate security standards in place, this particular aspect of the rule was not implemented. Just a couple of other enrollment changes I highlighted, most of which are not applicable because you happen to be physician groups. Groups are not subject to the application fee, but I just put it in for since there are quite a number of enrollment type providers and suppliers that are. There's also now the use of a temporary moratorium authority where CMS can impose a moratorium. So far to date, they've not used this very heavily. They've used it within the last year for some home health agency moratoriums and some ambulance companies. But basically, you will see this used if CMS believes there's a disproportionately high number of providers or suppliers based on the beneficiaries in an area, or a rapid increase in a particular type of enrollment in an area, and they want to just try to avoid having a lot of providers where there might be abuses that they can't control. So it's not used very often, but I wanted to put in some slides which talk about, who it applies to, how it works, and again, they'll be for your reference if you happen to hear that there's going to be an enrollment moratorium. I don't expect that physician practices, podiatry practices are going to come under a moratorium anytime soon. Another enrollment sanction that's available, though, is suspension of payments, and this is a scary one because all that is required is a credible allegation of fraud from a reliable source. And when CMS was asked what's credible, they said, well, it has to have an indicia of reliability. Well, that's not a very strong standard, and it can be set in place for 18-month time period. This has been used not very frequently, but it's been used for different types of things. I just heard of a suspension of payments put in place when there was a transaction and CMS wanted to be sure, what type of a sale it was, and they were trying to figure it out, so they just put a payment suspension in place because they thought that there was some potential problems with the transaction not being done properly. So it could be used for any number of reasons. So again, what are the consequences if you don't comply? Deactivation can occur, and that's with CMS, when CMS will just turn your number off so you can't submit claims, and they want to take a time period to be able to understand if things are being done properly or not. So for example, if they send a letter out and it comes back with a do not forward message because it wasn't delivered, they may deactivate the number until they make sure whether the post office made a mistake and it really was, you still were really at that address and it just wasn't delivered, or did you actually relocate and fail to report it. And a revocation is a permanent action where your provider agreement, your participation agreement is terminated, And except for adverse actions, there has to be a 30-day advance notice, but if it's adverse action, it can go back to the date of the adverse action. And revocations, unfortunately, end up almost being a death sentence because it's reportable to Medicaid, resulting in automatic termination after all appeals have been exhausted, and it's also reportable to other payers and often even reportable to licensing agencies. So it can essentially be a death sentence. Following revocation, in which the revocation authority began in 06, in 08, CMS said, you know, guys, you're still not complying with the enrollment rules. We gave ourselves revocation power, but you're still not being compliant with making sure that your enrollment data is kept up to date. So now if we revoke billing privileges, we're going to give you a mandatory 1 to 3 year bar to re-enrollment. So the bar itself isn't discretionary. There has to be a bar. It's just the length of the bar where there's discretion, although over time CMS has put some specific bar limits. So for example, a failed site visit, there's a 2-year bar to re-enrollment. It can't be a 1 year, it can't be a 3 year. It has to be 2 years. So again, initially when CMS started putting specific bars in, some of the MACs didn't understand those rules existed. So I had, for example, a failed site visit revocation where they tried to institute a 3-year bar. We argued on appeal, first of all, that the revocation was improper, but that it should only be 2 years and not 3. So then, again, almost a year later, CMS says, or less than a year later, in January of 09, CMS says, well, not only do we have to do revocation, now we have to give bar to re-enrollment. People still aren't listening, so now we're going to give ourselves the ability to seek an overpayment if you follow a revocation for only a few isolated situations, only if it was a failure to report a final adverse action or a failure to timely report a change in a practice location if the practice location change resulted in moving into an area that had a payment differential, and so the provider got more money as a result of not reporting the relocation timely. And so again, and then in September of 2010, a little over a year later, CMS gave itself again overpayment authority for DMEPO suppliers who failed to timely report a final adverse action. So what are some of the things you can do to ensure compliance? Certainly, I would strongly recommend that you have as part of your corporate compliance program that you have policies and processes specific to enrollment, making sure that your enrollment forms are complete, making sure that they're reviewed and dusted off periodically, making sure that you're using good procedures to gather data, making sure that there's processes in place where you have individuals confirming whether they've had any adverse actions in the past or notify you if there are any pending. Somebody who is responsible to oversee that process that really will get into the weeds and understand these rules so that they can make sure that you comply with the Medicare requirements. So now I want to just talk about a couple of interesting cases. This is a case where, and I see this, I wanted to raise this one. This is one of those situations where the buyer basically bought all of the assets from the seller, but in the time period while the buyer was getting its number, it basically leased everything back to the seller. So it leased back the equipment, it leased back the staff, it leased back, and took over the responsibility for that. And it took a percentage of the proceeds to cover the cost of all of those contractual arrangements. And this was a very common practice for people to use in transactions several years ago. It's not so common anymore, and it's not so common anymore because of the whole problem with having to be operational and who's the provider. So what ended up happening is the enrollment actually got approved, but before the PTANs got turned on, before the Medicare billing privileges got turned on, CMS basically stepped in and said no. By definition, the supplier is the entity that furnishes the health care services. In this case, the wrong entity is enrolled. The entity that really owns all the assets now is the one that should be enrolled. So the leaseback situation of entirely all of the parts to be able to provide the services is now looked upon as not being a proper type of an arrangement, and so the enrollment was denied. There are a lot of cases about effective dates of enrollment, and I put this in there just again because most of the cases deal with somebody just not timely filing, and the effective date is for a physician practice or an individual physician is the later of the date that the application was received or services were first provided. In this particular case, the only thing that appeared to be lacking was an original signature, and they were told to, send in another application with an original, which was done, and the second application was accepted, and the ALJ reversed, basically saying that CMS, in adopting its regulations, said over and over again that you should have an opportunity to cure, and why is it treated any differently than any other missing information? This is a particular one where I wanted to put this in because this deals with just reassignment. There are different rules for reassignment. So if you have a podiatrist join your practice who's already enrolled in your jurisdiction with Medicare but needs to reassign with you, there's a different rule for the effective date. The effective date of a reassignment in that case is determined only by the date the supplier began or will begin providing services. So you don't have that when it's received rule. And this was, there were a lot of us that were appealing reassignment cases time and time again and arguing, no, CMS, this is the section. Well, there now finally is a case that we can rely on where the ALJ went through the analysis that we've been doing and agreed that, yes, in fact, that's the case. And CMS attempted to argue that, well, wait a second, there were all these other cases that came before with reassignments that were decided differently. And ALJ said, sorry, CMS, you put in the manual the rules that should apply to a reassignment effective date. I don't know why the ALJs in those other cases, concluded that this wasn't just a pure reassignment, but that a new enrollment was required. But if it's only a reassignment, your own rules tell you you need to follow your guidance, and your guidance says this is the rule for a reassignment. There are a lot of cases dealing with revalidation requests that go unanswered, and so I just put in some of the timeline for this particular revalidation request. It was there was quite a bit of back and forth between the provider and the supplier, between the supplier and the MAC with respect to trying to get responses to development letters and trying to get additional and supporting documentation. And eventually the MAC basically said, sorry, you failed to complete your revalidation, your billing privileges are revoked. And in the case, the judge in the case basically said that they felt that the MAC was more than fair and reasonable in granting multiple attempts to correct the application well beyond the 60 days you have to complete the process, and felt like the providers just had a complete lack of diligence or a lack of competence in trying to participate in the Medicare program. So they don't look too kindly if the MAC does a real quick turnaround and tries to, say that you didn't adhere to the rules and only gave you one attempt. But if you get repeated attempts and you still aren't successful, you're not going to get a favorable decision in a case. This was a particular case where the sole basis before the court was whether or not the revocation was proper. And again, it's another one where there was a failure to respond to the revalidation request. In this particular case, the ambulance company was able to show that not one of the notices that were sent about the revalidation were sent to the right address. So again, this was a case where it was really good that the provider, the ambulance company, had their A55 copies on file. They were able to say, look, this is the address we reported. These letters didn't come to the right address. So the case was remanded in favor of the supplier. I talked earlier about licensing suspensions not being reported. This is a great example. This was a case where the Department of Health suspended medical licenses, but license suspensions were stayed, most of it, so they got their licenses back within the 30-day period that they would have had to report it, and so they figured, well, we got the license back, it hasn't been gone for more than 30 days, we don't have to report it. Unfortunately, the interpretation is incorrect. It is, the providers thought because the suspension didn't go on for more than 30 days, we don't need to report it, and CMS says, no, you have to report. Even if it gets stayed, you have to let us know about it. And then this is a particular one where the site visit was attempted on 2 days. They noted that the business was closed during the hour of operation. On appeal, the supplier provided various different pieces of evidence to show why they were open on that day. Delivery tickets, time cards, payroll data, floor plan showing how large the facility was that they may not have heard. The only thing that was relied upon by the ALJ was the site inspector's photographs of the car in the parking lot belonging to the staff person on the premises. So again, if the provider had been able, or supplier had been able to see before they got to the hearing that their picture of their car was in the parking lot, they would have had a better case to appeal, but they didn't. And then just another, just real quick case, talking about deactivations versus revocations. And unfortunately with deactivations, you don't have any appeal rights. But what was interesting about this case is that they tried to appeal it even though it was a deactivation. The ALJ went through a nice evaluation or a distinction between revocations and deactivations, but what I liked was some of the quotes from the ALJ that in taking away the ability to have a decision to deactivate as not being appealable, basically they're saying to CMS, if you're going to use something as powerful as a deactivation and take away any authority for anybody to appeal that decision, that you ought to do it very judiciously and for the right reasons. So with that, I know we're at the end of our hour, and I know I had a lot of information out there, but I did indicate that I would be willing to stay on for a couple minutes to take some questions, or if not, I will also entertain questions after the call in the next day or so.
Great. Thank you very much, Donna. I think we have 2 questions, if you don't mind.
I do not mind.
Thank you. And if we'll just, if any follow-up questions, we'll send those to Donna the next few days. One question is, if I'm starting a solo practice, how do I avoid being in a situation where I'm not operational yet, but I'm in the process of applying for enrollment and CMS comes for a site visit?
So that's a good question. The problem is that Medicare has always had in its rules that you have to be operational, and they expect that an individual is going to end up, individual or an entity is going to end up having to eat some of the costs of providing services. So one way you can do it is by starting with very limited hours, and of course posting those hours, and trying to take, and some payers, not all, some payers will require you to be Medicare participating, but others won't. So if you can start off and try to have non-Medicare patients, commercial payer patients, before, so that you start getting some revenue in, you're definitely operational, you submit your Medicare enrollment application. The other thing to keep in mind is you can also submit your Medicare enrollment application up to 60 days in advance of when you intend to open. So if you do that, you minimize the likelihood of the application taking a lot of time after you open to be processed. In fact, the application may be very near processing before you even open, or because site visits aren't required for podiatry practices, you may actually get the approval letter before you're ready to open. So remember, you can submit 60 days and up to 60 days in advance of the time you expect to be open.
One more question. If I'm changing my individual legal name because of marriage, what's the time frame process to change it with Medicare?
So you have basically 90 days to report a change that's not any of the delineated ones. You have to report for 30 days. But because the Social Security Administration file is reviewed by CMS, by the MACs on a monthly basis, my suggestion would be as soon as you get the change with the Social Security Administration, because you know that file is going to get transmitted, go ahead and submit the A55 paperwork to report it to CMS, because the MAC's going to get the Social Security Administration's file, and when they check those names, they could identify that it wasn't reported.
Great. Thank you very much, Donna. We appreciate it. Appreciate everyone attending tonight's webinar. As a reminder, the webinar and PowerPoint will be available on the APMA website at www.apma.org/webinars. Thank you and good night.
Good night.